Hello guys, welcome to Study IQ. I'm Safir. In this session, we are going to talk about the nature of Indian federal system. So we will discuss what is federal setup and then what is unitary, what is the nature of Indian federalism. So some believe that it is quasi-federal, and you will see in some textbooks it is written as federalism sui generis. That means it's a special type of federalism, not the one which you see in US or when we actually talk about federalism, it is two governments, right, at different levels. Now, if you might have remember, you have studied about diarchy in history, 1919 Government of India Act and 1935 Government of India Act. So in 1919, diarchy was introduced at the provincial level. 1935, diarchy was introduced at the central level, right? But when we discuss about diarchy, that is two setup, two government or two governance at the same level. Means provincial level, there is a reserve list and a transfer list. That means same level, two government, governor who is appointed by the viceroy and the elected ministers. So the two government at the same level as diarchy. But here, two government at different levels, and both have equal power and derived from the constitution. So both have derived the power from the constitution, both have equal power when it comes to actual federalism. But when it comes to Indian setup, whether it have equal power or center have some superiority or not, we will have to discuss. So that is why I've told you it is quasi-federal. There are some elements of federalism. There are some unitary elements also. So we will have to see what are those federal elements when it comes to our polity and what are those unitary elements as well. And then we need to conclude by saying that it is a federal setup which came into existence its own, which emerges its own. That is what federalism sui generis or quasi-federal, whatever conclusion you want to make, you can give. Okay, so what we are going to discuss, the topic name is nature of Indian federal system. So what we will be doing, we will be discussing what do you mean by federal and then what do you mean by unitary. Okay, so federal, as I've told you, it is government at two levels. You can just write if you want. Federal means government at two levels, both derive its power from constitution, both have equal power. Like typically what you see in US, right? So government at two levels. So when it comes to India, we have state government and central government. So government at the two levels. What is diarchy? Diarchy is the government, two government at the same level or two rule at the same level. Archy means rule. Diarchy means rule of two. So rule of two at the same level. Here, rule of two is there, center is also there, state is also there, state government is there, central government is there, but at a different level. So I just want to make sure this difference is very clear, that federalism is two government or rule of two at different levels. There is a state government, there is a central government. When it comes to diarchy, it is a rule of two at the same level. Provincial level, there was diarchy in 1919, and then central level also they have introduced diarchy at 1935. Okay, that means in the central level, if you see, viceroy is having that reserve list and the ministers have the transferred list. That means at the same level, two rule is there. Okay, so just write one line, guys, over there. Indian federal setup is, or we can understand Indian setup as quasi-federal or federal with unitary bias. Federal with unitary bias or federalism sui generis. These terms you can write because towards the end we need to conclude like this: quasi-federal, federal with unitary bias. Okay, and then the federalism sui generis, something which comes into existence its own. And one more important point that you can mention over there is that Supreme Court have made it very clear that federalism is a basic feature or the basics, it's part of basic structure doctrine. So it's a basic feature. So related to any provisions which is there in constitution, which is related to federalism, federal setup, it cannot be amended. Okay, so it cannot be changed. So basic structure doctrine, I hope all of you know. So federalism is a basic feature of the constitution. So now let's look into the arguments in favor of Indian polity is federal. Okay, and then we will see the arguments against also, or we can see what are those federal elements and what are those unitary elements, and then we will try to make a conclusion. So if you get a question in mains, this is how you need to proceed. First, you have to tell what do you mean by federalism, two governments, derive power from the constitution and equal power, just like US. But in India, there may be some unitary bias. So it's a quasi-federal setup. Some is there, some is not there. It's not exactly like US. It's not exact federalism. Okay. So complete autonomy is not there. There are some instances where center exercise more authority or more power. So we will have to see what are those federal elements and what are those unitary elements as well. And then we will make the conclusion. Conclusion is federalism sui generis. It's a federal setup of its own. Okay, that's totally different from other federal setup that you see. So first and the most important one is the written constitution. Okay, so we have a written constitution. In the federal setup should have a written constitution. Everything has to be properly documented. Okay, so there will be proper distribution of power and everything. So just write one line. A federal constitution necessarily is a written constitution. So we have a written constitution, so that support the argument. The second one, division or distribution of power. Distribution of power. Now, from where, how the power is divided or how this distribution is done, who did this? It is a constitution. So from where the governments, the state government and the central government will derive its power, it is from the constitution. So constitution makes it very clear about the division of power. Okay, so just write one line. Constitution have clearly divided the power between the center and the states. Okay, so both you can see derive the power from the constitution. So can we say one is superior over the other? No, actually there is no question of inferiority or superiority here. Both have their power, which is derived from the constitution. So there is a clear-cut distribution of power or division of power. Okay, and in fact, the center and the state should be coordinating bodies. Ultimate objective is the welfare of the people, of the population or the citizen. So both of them are actually supreme in their respective areas. So center, there are areas in which they are supreme, and when it comes to state, there are different areas in which state exercise the authority. Both derive its power from constitution. So constitution make it clear what is this division or the distribution of power. Now the third one is related to rigidity of the constitution. Now guys, we will be seeing about this topic later also, whether the Indian constitution is rigid or flexible. What are those rigid provisions? What are those flexible provisions, like that? But rigid constitution is required for a federal setup. So we have a rigid constitution, right? There are certain areas where the amendment is very difficult. We need the permission and the consent of the states and all. So it is a rigid constitution. Federal constitution has to be rigid, at least in important areas. And in important areas where it affects, like when it comes to Supreme Court related aspects, High Court related aspects, election of president. So these kinds of provisions, you see, the state government consent is required, right? Next is independent judiciary. Guys, for federal setup, independent judiciary is very much required. Now, remember, when I say High Court, it is not the state's court, right? When I say Supreme Court, it is not the court of the center. No, that's not the case. Both are actually independent. Okay, so when there is a case between center and the state, it will be fought in the Supreme Court, and it is actually the original jurisdiction of the Supreme Court. So we have an independent judiciary. So that also support the argument. We need an independent judiciary because, see, ultimate objective of the Supreme Court is to, go with the constitution and constitutional values and to protect the constitution, right? The fundamental rights and the constitution. So the Supreme Court have to make sure that nothing in the constitution is actually violated, whether it is distribution of power or basic structure doctrine or whatever it is. So in case if there is any dispute between the center and state, it will be taken care by the Supreme Court in accordance with the constitution. So whatever powers has been given by the constitution, it has to be exercised as per the legal provisions. Okay, so independent judiciary. So that also supports the argument. And then you have this one, supremacy of the constitution. Constitution is supreme, right? Supremacy of constitution. That means there are certain areas, if you need to make amendment, it has to be approved by both the center and the state. So normally you go with the bill, or you want to do something, you want to come with a law or something, whatever it is, if you want to make some amendment. So in the constitution, in normal scenario, you can just do that in the parliament itself. Both the houses of the parliament need to be passed. But there are certain items, important areas where you need the assent of the state. For example, if you see election of president, this one, Article 54, 55, right? It has to be approved by both the center and the state, election of president, because there is a role of state in the election of president. So if there is any modification which has been brought in, it has to be accepted by the states, right? And then again, when it comes to Article 73, the extent of executive power of union. So in case if there is any amendment, the extent of executive power of the union, if they want to extend it or if they want to cut down it, still you need the support of the or consent of the state. Same way, if it is 173, then 162, it is the extent of executive power of the state. Okay, so in case any modifications or amendment is done in these areas, you need it should be approved by the center and the state. And also Article 241, high courts in the union territory. And then if you see, so this is the first area where you need approval of center and the states. Okay, so like Article 54, 55, and then 73, and then 162. So 73 is the extent of executive power of union, 162 extent of executive power by the state, and 54, 55 election of the president related, 241 high courts in the union territory. So here you need it to be approved by center and the states. Now, second category is approved by center and 50% by states. Okay, so here I'll just write center and state. Now center plus 50% of states. Okay, so what are those? That is the second category, like chapter 4 of part 5. What is chapter 4? Chapter 4 deals with judiciary. Okay, part 5 deals with union. So judiciary at the union level, what is that? Supreme Court. So anything related to Supreme Court, you need, the approval of center and 50% of the states. And also chapter 5 of part 6. What is chapter 5? It is again judiciary. Part 6, it is at the state level. So judiciary at the state level, I'm talking about high court. So guys, the point is anything related to Supreme Court and high court, you need to get it approved by center and 50% of the states. Also, chapter 1 of part 11. What is chapter 1? It is legislative relation. Part 11, center-state relation. So the center-state legislative relation is also important here. So any modification in these areas, you need the approval of center and the state, and also the different list. There is a union list, the state list, and the concurrent list. Any modification in that, then also you need the support of the state. Any modification in 368 itself, you need the support of the states, approved by the states. Okay, and again, representation of states in parliament. Okay, all these where you need to get it approved by the center and the state. So this is what I mean by supremacy of the constitution. Neither center alone nor state alone can amend the constitution. Just write that point. Neither center alone nor state alone can amend the constitution, at least in important areas. And there are 5 major areas. So the first one I've discussed, like that 55, 54, 73, and 162, and 241, like that. And then we discussed about judiciary at the center level, judiciary at the state level, Supreme Court, High Court, and then what else? Then we have discussed about 3 different lists, and then 368 itself, and then the representation of states in parliament. So these are 5 areas. 5 areas, I think you can refer to Lakshmikant also. In these 5 categories, the amendment in the constitution is first passed by the parliament with a special majority, means 2/3 of present and voting. Okay, and then minimum 50% of the state legislature should approve it by simple majority. Then only it will be sent for presidential assent. Okay, now when we talk about federalism, I've told you these are federal elements, but there are certain distinctive features when it comes to Indian federal setup. Like in US, if you see, there is double citizenship. We don't have that. Right. So same way, we will have to see the distinctive features of Indian federal system. That means there are some federal elements as we have discussed, but there is a unitary bias. So this is federalism sui generis, which is very specific to India. Okay. Now, if you see, when it comes to American Constitution, the states have their own constitution and each states have their own Supreme Court also, but that's not the case with Indian setup. Okay, so there is no different constitution, there is no different Supreme Court for the states. And secondly, if you see related to the citizenship, there is no concept of dual citizenship when it comes to India. And also under Article 352, we will be discussing about this. If there is a national emergency, that distribution of power between the center and state will be altered and it will be suspended. Okay, so Indian Constitution is actually designed like federal setup, giving independence and autonomy to the states, but at times it will turn out to be unitary. There are unitary bias, okay, because there are a lot of things which we need to take into consideration, that regional aspects, religious aspect, casteism, and all those things are there. And considering this diversity, some kind of unification factor is very much required. Otherwise, it may lead to secessionist tendencies. And if you see, during the time of independence and post-independence time, there were a lot of instances of secessionist tendency, right? And it was very difficult to bring all those princely states at that point of time. So that is the reason why there are some unitary elements, which is very much required. So you can say the historical context, the secessionist forces. Okay, now what are the unitary features? Okay, guys, if you see Schedule 7 of the Constitution, Schedule 7 of the Constitution distributes the power between center and the states. So in that you will see union list, state list, and the concurrent list. And most important areas are coming in the union list. Not only there are more number of items, but most important areas also will come in the union list. And even if you see the concurrent list, which is largely biased in favor of the center, even the financial distribution is also like that only, such that center control more financial resources when it comes to taxation and everything. Center control more financial, obligations, right? The resources actually. So this list you can talk about. That is first and most important thing. You can talk about the financial distribution, center control more resources. Okay, and then Article 249. Article 249 is very important. Center can also pass law on state subjects, okay, if Rajya Sabha passes a resolution with respect to that regard. So just write one line over there, which is very important. Under Article 249, if Rajya Sabha passes a resolution by special majority means 2/3 of members present and voting, that it is the interest of the nation, the parliament must legislate on a specified state subject. So Rajya Sabha passes a resolution with a special majority in the interest of the nation, that the parliament has to pass law on the state subject, specified state subject. Then the parliament can pass law on that particular state subject, and it will be in force for 1 year, and it can be extended also. Okay, it can be extended any number of times. So Article 249 is very important. Center can legislate on state list. Another one, Article 250, that is related to national emergency, just right. Under Article 250, during national emergency, Parliament assumed concurrent legislative jurisdiction over the subjects mentioned in state list. Concurrent means parallel. State can also legislate, center can also legislate on the state list. Normally, state list will be only by the state, but during the national emergency, there is a parallel legislative power between the center and the state on the state subjects. Obviously, central subject union list, it will be only center. But the state subject is what I'm talking about, because we are talking about the unitary features of Indian Constitution, where center exercise more authority or more power, or where things are biased in favor of center. So I've told you in that Schedule 7 itself, when we talk about the list, union list is much more important items. Concurrent list is also biased in favor of them. Financial distribution between the center and state. And if you see, the resources are mostly with the center, and 249 and then 250, 252 also, guys. 252, just write that. Under Article 252, two or more state legislature pass a resolution authorizing the parliament to legislate over the state subject. Then parliament assumes legislative jurisdiction over that state subject, and the law remain in place till the time same law is repealed by the parliament itself. So what I'm saying is, under Article 252, if two or more states, see, for example, Kerala and Tamil Nadu, they have a common problem, or some Naxal affected area, they have a common problem. So the state law may not be enough. You need a very good coordinating force to tackle them, or you need more resources. So in that case, when two states are facing common problem, rather than making separate laws for them with respect to each state, they will ask the center to legislate upon a state, even though it is related to state subject, center will legislate upon it. And then that law will be in force for any number, till the time it is repealed by the parliament itself. So once this is enacted, once this law is passed, then only parliament can repeal it. That is very important. States cannot do anything. State, if authorize the center, then center pass the law, then only parliament can repeal it. So 249, 250, 252, or 253 also. Okay, just right. This is related to international treaty. For complying with any international treaty, center can legislate on state subject even without the permission of the state. Just right. Parliament can pass law on state subject with or without the consent of states for implementation of international treaty. Now, last one under this, Article 355. So, guys, Article 356 is President rule or the state emergency. So, under Article 356, when President rule is imposed, the state legislative assembly will get suspended or dissolved. It could be anything. Then Parliament may assume the jurisdiction of the state subject for that state. So under 355, Parliament will take. See, I've discussed about 250. 250 during national emergency, that is a parallel legislative power. But President rule means state legislature is suspended. They are not going to pass any law. State, or it is dissolved. So the Parliament may take control over that. National emergency is different. State government is going on. Legislature is there. So there is a parallel jurisdiction. Okay, but when it comes to President rule, the Parliament will take control of it. So guys, remember this Article 249 is very important, 250, and then 252, 253, 355. And now residuary list. If you see, Article 248 is talking about the residuary list, right? There are three lists. You can see union list, state list, and the concurrent list. Apart from that, Article 248 is talking about residuary list, and residuary power of lawmaking belong to the Parliament. That means if things are not coming in any of the three, whatever is mentioned in Schedule 7, which I've discussed already, I have told you, Schedule 7, union list is there, state list is there, and the concurrent list is there. And union list itself is having many numbers, many items. Not only that, it is having important areas. Beyond that, concurrent list also center control. Now, if something is not mentioned in this, because new areas are coming, right? New areas are emerging. So with time is changing. So things which is not mentioned in constitution at that point of time, new areas are getting added. So if you need to legislate upon that, so who will take care of it? It is the center. So the residuary power is with the center. Then various other areas which you can mention under Article 155. Governor is appointed by the president, and in fact governor serves as an agent of the president, right? So you can just write governor appointed by president who holds office during the pleasure of president, and through governor center can influence the state administration. Obviously a president rule can be imposed and many things can be done, political things can be done, right? And then next is Article 312. 312 is related to All India services, just right. Under Article 312, Rajya Sabha can authorize the Parliament to create one or more All India services. Why I've discussed All India service here? Because All India services actually, they're appointed by the center and are controlled by the center. They belong to the center and they will work in the state. So through these officers, actually, since their commitment is towards the center can control the state administration to an extent. So that way also it is unitary. So they are largely functioning under the state government, but their disciplinary control and everything is with the center. Like Ministry of Home Affairs will take a DOPT, right? All these are at the center level. Article 256 and 257, just write one line. The center can issue administrative direction to state indicating the manner in which railway properties and means of communication shall be maintained. And if there is any problem, if the state is not willing or not doing it properly, that can be a reason for implementation of the president rule, imposition of president rule also. Okay. So, and if ignored, center can dismiss the state government under Article 365. That can be leading to president rule. So that is very important. And then unequal representation of states in Rajya Sabha, depending upon population of the states. That is something which you can write. And even the 12 nominees of the president, who's also in violation of federal principle, right? And then Article 324, there is a common and independent election commission for holding election both at the parliament and at the state level. And then CAG carries audit function of center as well as state, and it is appointed by the center, right? Appointed by the president and removed by him with the approval of parliament. So sometimes state complain about the biased nature of his office. That means this is also actually against the federal setup. So I've discussed so many points related to unitary features. So you can write that where center can legislate, right? That is very important. That Article 240, 250, 249, 252, all those things are very important. And these areas, residuary power is with the center. If something is not there in any of the list, it should be with the center. So now what is the conclusion? So we discussed about what is federalism, what is unitary setup. We have seen what are the federal features, what are the unitary features. Now the ultimate thing that you need to write here is we designed to be federal, means we need to give autonomy to center as well as states. Both have their respective area, both derive the power from the constitution. There is clear-cut division of power, distribution of power, and which is actually made sure by the Supreme Court that it is not violated also. And the Supreme Court was actually entrusted with the power to check these kinds of violation of distribution of power. So it is actually a federal setup, but there are certain elements which makes it unitary, like these centers control over different lists, and then All India Services, Election Commission, CAG, Governor. So these are unitary features. So it is not exactly like US, what you see. There is no concept of dual citizenship. There is no concept of separate constitution for the state. So things like that you won't find in India. So we are a federal setup, but it's a federalism sui generis. It's something which comes into existence its own, and it is our own version of federalism. So that is how you need to answer, or it's something which is like quasi-federal you can write, but I would say federalism sui generis, something which comes into existence its own, something which evolved over a period of time. Okay, I hope you understood, guys. See you soon in the next session. Thank you so much.